Hello, everyone. We're going to get started in about 2 minutes, so just hang back and relax, and we'll be with you in just a moment. Thank you. Okay, we're going to go ahead and get started today. Hi, everyone. My name is Michael Ibrahim, and I am the program manager with the Cultural Investment Portfolio at the Mass Cultural Council. The Cultural Investment Portfolio's focus is grants and services for nonprofit cultural organizations, and we are excited to deliver today's workshop to you today, Nonprofit Suspension and Closure. This workshop is part of the Mass Cultural Council's Recover, Rebuild, and Renew efforts to help organizations come back from COVID-19. This spring, we're offering 2 free workshops every week, every Tuesday and Thursday, in the areas of financial management, legal issues, human resources, advocacy, management, and board governance. If you have a moment, feel free to introduce yourself in the chat with your name, your organization, and title if you'd like. Joining us today are Jim Grace and Luke Blackadar from the Arts and Business Council of Greater Boston, and Judy Polachek from Polachek HR Law LLC. While they're going to introduce themselves in just a minute, I just want to go over a few ground rules. As you probably noticed already, this session has automatic captioning. Auto-generated captions are provided on all Mass Cultural Council Zoom meetings and webinars. To request additional accommodations to ensure your participation for future webinars, please let us know of your needs when you register. If this is distracting for you, you can hide this by clicking Hide Subtitles in the closed captioning options at the bottom of Zoom. We will have time for questions throughout the presentation. We ask you to please use the Q&A function and not the chat to ask questions. If you want to ask questions anonymously, you will find that you have that option in the Q&A. This session is being recorded and will be available on the council's website and YouTube channel afterwards. You will get an email from me probably tomorrow when this is ready, including the resources, and feel free to share that to any stakeholders you may have. My colleague Sarah Glidden is here, and she is providing some resources in the chat box, so make sure you take a look at that. We'll have many resources in future sessions to take a look at there. Additional materials, including this presentation, will go out along with the email to watch the video tomorrow. And right now we've got this clock for about 90 minutes. We may go a little less than that. We'll see how we go. And with that, I'd love to turn it over to Luke.
Great. Thank you, Michael. I'm Luke Blackadar, the director of the Volunteer Lawyers for the Arts of Massachusetts, which is a program of the Arts and Business Council of Greater Boston. And basically my role is to help provide affordable legal services, pro bono legal services for artists and arts organizations needing legal assistance. And, you know, we've been certainly more active now because of COVID. And even though we're kind of a little bit more adjusted to it now, we're still finding there's been a lot of need and a lot of support for nonprofits as they continue, you know, strategizing how they're going to continue moving forward. So before we get into the conversation, I'm going to let Jim and Judy introduce themselves as well.
I'm Jim Grace. I'm the Executive Director of the Arts and Business Council. So thanks for joining us. And for those later on listening, thank you for participating. It's been a great to work with the Mass Cultural Council on this series. So we appreciate their leadership in this space and really appreciate getting a chance to host these different workshops. And I really want to be kind of to introduce Judy Polachek. I have known Judy now, I think, for almost, I don't know how many years it's been. I used to teach a class at BU on arts administration. She always used to come and be our HR legal guide. And so we've been working with her at the Volunteer Lawyers for Arts for many years. So we're so thankful that she's here today to add her expertise from the perspective of HR and nonprofits and arts nonprofits in particular, which she has experience with. So Judy, thank you for all your support over the years, and thank you for participating today.
Right back at you, Jim. I'm an HR lawyer. I spend my days advising and counseling businesses, any type of businesses, not-for-profits, for-profits, large and small. I counsel them and advise them on how to manage their workforces. It's mostly about complying with the law and solving problems and preventing litigation. Because I began my career as a litigator, and I found that, at least in the employment and HR space, my impression was better to avoid the litigation so that everybody can focus their energies on getting the work done rather than fighting the fights. I wanted to share my appreciation to all of you for keeping the cultural life in Massachusetts active. I used to work in arts administration before I became a lawyer, and I spend a good hour of my day singing for my own personal satisfaction. I have a deep appreciation for arts and cultural life, and thank you all for what you do.
Thank
Well
you, Judy.
said. So today we're talking about nonprofit closure, suspension, dissolution, and a little bit of bankruptcy. And really, this is kind of one part of a discussion on, business exit strategies generally. Why have this discussion? It's really, COVID has changed everything. We know that. It's forced a lot of organizations to reevaluate themselves and determine, how long is my runway? Is it indefinite, or do we need to start thinking about how, do we have to make some organizational changes in order to either, continue surviving or, to continue carrying on our charitable purpose and our objectives. So this is really, it is not, because I know when you see nonprofit closure, suspension, dissolution, it sounds like a 5-alarm fire and doom and gloom, but it's really just to start introducing some of these topics and some of these options and possibilities. And really, honestly, for organizing and strategizing for your organization's survival. But obviously, any type of structural change, any type of major organizational change, such as dissolution, bankruptcy, or later on in a subsequent workshop when we talk about mergers, acquisitions, and absorptions, there are legal consequences and major obligations that you have to be aware of, and that can cause a lot of traps and can cause issues if you're not prepared to address them and you're not equipped to have a productive conversation with either your board of directors, your staff leaders, and any types of business professionals who are going to support you, be it an attorney, accountant, etc., insurance adjuster, what have you. So really understanding the basic legal framework, and this is something that Jim and I go on about all the time, just understanding the vocabulary and the basic framework and the kind of legal scene that we're working in here makes such a difference in your ability to have a more productive conversation with a service provider, and also to really help you actually advance your goal, because a lot of us lawyers sometimes jump immediately to tactics before thinking about, okay, what is it? Does this actually solve your problem? So that's where a lot of understanding this framework helps a lot. And the reason we have Judy here is because a lot of these decisions are going to have consequences for your personnel, your talent that is working for you and providing labor and skills. And all of these decisions, when we think of the financial solvency, we worry about big debts, big obligations, major assets we have, and sometimes overlook the assets that we have right in front of us, the human capital, the people who are making the machine work. So with that said, we're going to start with HR, human resources, and best practices. But the general overview is we're going to talk about HR and kind of what we need to be thinking about with respect to caring for our personnel as we start thinking about making major structural decisions, and then talk about the nuts and bolts of what does it mean to dissolve a nonprofit, particularly here in Massachusetts. It's not as easy as a for-profit. And then we're going to do a brief introduction to Chapter 7, and this is a typo, it should say Chapter 11, bankruptcy, liquidation, and restructuring. So let's start with HR.
Okay, great. Thanks, Luke. So Judy and I are going to take this piece of the conversation, and I want to Also support what Luke was saying around, this is about intentionality. It's about planning, and it's about having these conversations. I think this kind of workshop also fits nicely with the nonprofit finance component to this series at the Mass Cultural Council, because often you're having financial conversations and then you're saying, but if you do this, what's the consequence? If you do that, what's the consequence? So this fits into a larger conversation of strategy and planning and intentionality. So I really want to support that framework of this. And so really we just have some key points on the HR. So Judy, we're going to do this in a little bit more kind of question and just kind of dialogue, back and forth, but we put this up to help kind of prompt. So when I think about kind of best practices, if I were kind of interviewing you, if I was an executive director, kind of interviewing you, getting ready to have this conversation with my board or funders or other leaders, what would be some of the topics or some of the main areas that we would discuss, kind of starting with kind of clarity of status?
I think I would begin the conversation by commending you for starting this conversation before you take action.
Mm.
In my experience, counseling businesses, it isn't uncommon for for-profit business owners, just like not-for-profits, to try to keep things hidden and work side deals when they start to feel financial pressure and urgency. Um, and the hope sometimes is, if I can get somebody to postpone receiving their bonus, or if I can ask somebody to just take half salary now and I'll pay them back in 6 months when we're in a better cash flow status, then no one will know we're having financial problems, and I will manage the situation in an under the table financial arrangement. It's an understandable inclination, because if it's successful, it would allow you basically not to have to face the financial crisis or difficulty you have in the moment. But it's not a good strategy in any way. It's financially risky. It puts you in a liability situation you didn't have to be in. Um, and I also think, in terms of an employee relations position, it puts you in much worse status, because you're asking favors of workers, and that's not the right relationship to be in with your employees. And so, face it, when you're in financial straits that are going to make it hard to meet your payroll, start the conversation, start the meeting, and make changes, whatever you need to do now. Don't make side deals or ask people to voluntarily cut back on what they are owed.
Okay, great. Appreciate that. And with respect to kind of this kind of thinking about when choices that you make when funds are running low, and this idea combined with this idea of change of employment status and getting creative about what can you do, what are the terms, what are the consequences, creative options and goals, kind of under 2 and 3. Can you speak a little bit more to that conversation that you advise your clients on, or how you would engage in a conversation with the board or with the senior staff?
Sure. Actually, and Jim, I'm going to ask you, should I also mention the payments that are most urgent to keep making, or should we think more
Absolutely.
broadly to begin with about creative structuring?
I would say, however it flows naturally, as if we were having a conversation as a client. I think no matter what, we definitely should highlight for folks on this call and later, what is kind of the waterfall of definitely shouldn't do, or definitely payments you must make. I think that is an important part of this conversation.
Well, I think that does flow in the waterfall visual too. It flows at this point in the conversation because I'm a lawyer. My job is to minimize risk and to educate you and any business owner or the person running a not-for-profit about the worst case scenario and about how to think about your workforce. And so here's kind of uh, the absolute don't, or the urgent obligation you have. And I'm guessing if you all run cultural organizations in Massachusetts, you're very well aware of this. But the legal obligation that's going to hurt the most if you violate it is the obligation to pay employees the wages and compensation that they're owed. So extra things like benefits, like paying for their T-Pass, I don't know, maybe that's going to be in the gray area. But if they are owed wages that you pay as an hourly rate or their salary, you must pay that, because the consequences of not paying wages are dire. There are huge penalties for failure to pay, and the whole employment legal system is designed to protect the vulnerable worker. And obviously, the thing they need the most from us is their wages. And just so you know, accumulated vacation time that they have not used, that actually is considered wages under Massachusetts law. So when you think about the money you absolutely have to pay your workers, it's their wages, including unpaid vacation time that they've accrued but not used at the time they leave your employment. So you'll get into huge trouble if you don't pay those things. And the other thing that I'm sure makes sense to everybody that goes in this category of urgent must pay, do not cut corners on this, is payments that you have withheld from your workers' compensation in order to pay their income tax obligations to the Department of Revenue and to the IRS. In your regular payroll, you've held back some money to pay taxes. That's not your money. It still is the employee's money. So it has to go to the IRS and the DOR no matter what. Don't be tempted to use it for something else.
Judy, what about also taxes in the sense of, you think of employment taxes? We have gotten calls in the past at the VLA where, funds are running short and all of a sudden you're stressed not to be able to pay the employment portion of the tax.
Well, the employment portion of the taxes are made up of the withholdings, which, as I said, is the employee's money, so you better pay that. Probably unemployment benefits taxes, if you pay it as a not-for-profit, that is probably one of those things you think of as employment taxes. Yes, you should be paying that because it will help make sure that your workers are entitled to unemployment benefits if you fire them. So that's worth doing. FICA, Medicare. I don't know what the penalties are offhand of not paying it, but no doubt that's something that that the federal government will notice if you don't submit those payments, and you're likely to get fines, and you won't be able to get out of those obligations. So going back to the theme that I began with, the minute you think you're going to have trouble meeting your financial obligations, that's when you need to change the worker status or their compensation to avoid accumulating obligations that you don't have the money to pay.
And let's go a little farther on kind of changing status. So when you say no, can you go back? Yeah. So changing status, what do you mean by that? And maybe what are some of the terms? Like, what are some of the options when you say change status? What are you referring to, from going from maybe full-time to part-time, or what?
This is where I think you all, as directors of cultural institutions, are going to be good at this, because there's creativity in your options that I think a lot of conventional business owners can't see as quickly. What I can assure you all is there are very few laws that define what full-time is, for instance, what part-time is, how much somebody has to work in order to be compensated in a particular way or have a particular title. And so at that moment, when you realize that your finances are tight and you need to change something quickly, you don't need to terminate right away. That's not the advice that I'm trying to give, or the information I'm trying to share. I will proceed and share the information I want to share in a moment, but that reminds me to tell you that nothing I'm saying today is actually legal advice. I'm a lawyer, and these are the types of conversations I have when a client actually engages me and hires me to represent them. But what I'm telling you now is general information about the employment laws and how to apply them for your organization. You cannot understand this to be actual legal advice. Don't rely on this as legal advice. If you need legal advice, I do advise you to hire a lawyer. That said, the information I can share is that if you are having trouble meeting your bills, and you're not ready to actually terminate employment because things are uncertain or because you haven't figured out what the best organizational structure is going forward, um, you, in many cases, because we have an at-will employment regime here in Massachusetts, you can reduce their hours or reduce their pay. It's a unilateral decision you make. It's not a compromise you make with the worker, because the worker wants the money and needs it. And but nonetheless, if you're in that pinch, you do have an option to either demote somebody, change their job title so that it is less demanding, less responsibility, or to change their schedule, fewer hours, fewer demands, shorter hours, or simply leave them at the same job and reduce their compensation. And again, nobody wants to do this. It's an unfortunate thing to do. But nothing in the law, in most situations, nothing in the law stops you from doing it. And then again, from an employee relations perspective and an equity perspective, I often find that it's a humane way to manage a tightening budget with your workers. If you reduce compensation for everybody, then at least everybody can still hopefully pay their rent, and buy a little something to eat every day. Um, so those are some ideas.
And then can we talk a little bit about it? So let's say if you move through this progression and you either furlough somebody or they're changed in status, obviously with the PPP, it has given organizations opportunities to keep their employees fully staffed or part-time staffed. But if we do move our through, and there's executives here and nonprofit leaders here that do have to terminate, we have this little prompt here to talk about kind of wages and benefits, and then also separation agreements. Can you speak to that as we think about progression here?
I will. And the funny thing is, some of the terminology, again, is not defined in the law. And so you have lots of options. So if you get to the point where you feel like you cannot keep somebody on your payroll, you do still have options. Jim, you mentioned furloughs. And a lot of companies have used furloughs to get through the past year. And a furlough, again, in most respects, doesn't even have a legal significance. So you can invent what a furlough is going to mean based on your needs. A furlough can mean go home and don't do any work for 2 weeks. And then one of your colleagues will go home and not work for the next 2 weeks, and you'll come back and work and we'll pay you. And that often serves a business's needs, especially because conventional thought and the way most companies do a furlough is that the worker maintains their health insurance while they're furloughed. So they don't get their wages and they are not active workers, and they can take other jobs or they can finish the projects at home they wanted to finish. They don't answer any questions. You have to make sure that you don't call them up and ask them to answer an email here and there, because then you're at risk of actually being obligated to pay their salary since you've asked them to do some work. But if you don't ask them to do any work, you could continue them on the health insurance plan while they're on furlough and wait to see what happens. And at the end of a furlough, you can either extend the furlough or you can terminate their employment, or again, change their status so that they either have a different job title or a different compensation or whatever. Any of these changes you're going to make, I strongly advise you to make them in writing. Again, there shouldn't be any side deals or secrets or under the table arrangements, because in my experience, that's where the conflicts arise. Is there misunderstandings about how much they were going to get paid while they were while their hours were reduced, or whether it was voluntary or involuntary, this or that. So whatever the new arrangement is, make sure to write a memo, an email, or preferably a letter on the letterhead of your organization saying, here is your change of status. Here's what we discussed today. Here is the decision we made, and here's the way it's going to be going forward. You can always make more changes. You're not stuck with that arrangement you set. But don't let yourselves get into a situation where a worker can say 2 months later that you promised to pay them half salary and that you failed to do that. Because I've seen so many situations where the business owner says, I never promised that. But I did tell them that we were going to reduce their salary a bit, or make some different arrangement. There's, if you can't demonstrate that you communicated the decision you were making to the worker, you're going to have trouble in that conflict, having your view of reality prevail. Well, Jim, I apologize. I haven't quite gotten to answer
That's
directly
okay. No, that's
the
good.
question you
That's
asked.
before. Yeah, that's good. Well, the question back is a little bit, because I almost think that goes back to the previous one, where goals to some extent. So with respect to making a proper termination, so what are some of your best practice advice that you give clients around that step? And then in some ways, the consequences either through wages and benefits due to that decision. And then some organizations use separation agreements to either limit their liability or potentially to give some type of severance as part of that. So or you can take those as separate questions, or if you wish, you can combine them if it's easier to answer in that way.
Well, a termination of employment means the employment's ending. And so the person is not going to have a relationship with the company anymore, unlike someone who's on furlough or is an inactive employee. So you still include them on their list in the hopes you're going to give them hours again in the future. Termination means it's over. And it does mean you can rehire them if you want to. So if you have uncertainty in your finances going forward, and you don't want to give someone the impression that they will have hours in a month, or that they will have a salary or project to do in a month, termination, it might be the right answer. And then rehiring them is always an option. The sort of starting and stopping the relationship isn't even that complicated in a lot of situations. So that's what a termination is, and use it when you need it. When you terminate a worker under Massachusetts law, you're obligated to pay them any wages you owe them. As I said, including the payout for accrued unused vacation time, if there is any, money you owe them in reimbursements, whatever kind of money you might owe them. And you should you're obligated under the law to pay the wages out on the day you terminate them. So there is absolutely no excuse for not meeting that obligation, because you're the one who's initiating the termination. So you can prepare by having the check ready. And if you don't meet that obligation, it is incredibly easy for your former employee to march down to the Attorney General's office and make a complaint. And there couldn't be a clearer violation of the law that they could complain about than failure to pay wages on the date of termination. In terms of when the benefits end, if you give any kind of insurances as benefits, the nice thing is that you might have paid a whole month's premium in advance for the health insurance. And so it's possible when you fire the person, you can let them know that your insurance payments, we're not going to pay anything more for premiums after today, but you can know that you're covered for a few more weeks. And check with your insurance broker first to see if that's true. But in some cases it's true, and it's nice because it eases the sting of this sudden loss of work and compensation. There are a couple other odd obligations you have on the day you terminate someone that you might not know about. The first is that you're obligated to give your workers notice of their right to apply for unemployment insurance benefits. And so there's a form you should just download from the Department of Unemployment Assistance website and attach it to your termination notice, just to meet the obligation. And it's nice because then the worker does know how to apply for unemployment benefits. I know it's possible some of you aren't bought into the unemployment benefits system, so it will be more complicated for you, and you can get advice about that. But you are supposed to give unemployment notice with your termination notice. Obviously, if you are offering health insurance, then you have to give COBRA notice when you terminate somebody. And then some other elements of a termination communication. Usually it should come in a letter. It always should come in writing. And it should identify the date on which the employment ends. But in that communication, you should also very explicitly let people know that their access to the electronic resources of the organization ends that day. And you should make sure that their electronic access to your organization's email and any electronic digital resources, intellectual property, software licenses, you should make sure it ends that day. For so many reasons, it is not a good idea to let them to continue using your intellectual property or electronic resources after that day. So let them know it's ending and make sure it does end, and take the computers. It might feel petty and uncomfortable because, especially in a not-for-profit cultural organization, I imagine the expectation is you want to be generous with the hardware. And you might be able to let them keep the hardware, but you cannot let them keep it unconstrained. So you should control the change of ownership of the computer if the person's going to own the computer going forward. And if they're not going to own the computer, get it back. Have them deliver it to you. Go to their house and let them bring it out. Again, perhaps this is obvious to you all because this is 2021, but I found that especially with larger companies, it took them a while to evolve to be more aggressive about the way they handle electronic equipment and resources when the employment ends. So do that. And then I'll wait to see if you all have questions about those type of issues before we move on to severance and separation agreements.
Hey, Judy, this is Michael here. I do have a direct question that came into me when we were talking about changing the terms of employment. What about an employee that has a contract with the terms of employment? Can those be changed?
That's a really good question, because the terms can be changed very easily if the worker's an at-will employee and no contract has ever been made and no promise of of a certain duration of the employment or promise that the compensation is going to come in at a particular level, particular period of time. A lot of workers have contracts with their employers that aren't actually employment contracts guaranteeing the same terms and conditions. A lot of them actually have agreements that are only about non-disclosure and the ownership of intellectual property. And they don't say anything about how long the employment's going to last, for instance, or what the salary is going to be. So if the contract is one of those, which really is about non-disclosure and ownership of property, it's not going to affect the agency or the organization's freedom to unilaterally change the compensation. Whoever's making those decisions is going to need to look extremely carefully at the contract, read the thing, and see whether or not it leaves you open to make those kind of unilateral changes. And in fact, any one of the things we've been talking about today, any one of the changes of status, the mild ones or terminations, you can't do it without reading the documents that you have in place. It's the contracts you have in place, the offer letter, or whatever offer you gave in writing to your workers when you first hired them, any promises that you made to them during the course of their employment about how things were going to be, and any employment manual or handbook or policies. You must absolutely read them before you change status, because in some cases those documents constrain you. Sometimes those documents make promises that you won't, for instance, cancel health insurance without 90 days notice, or they promise that you only reduce salary after a written warning and an opportunity to cure. So whatever you're doing, the freedom is limited by what you've promised in the past. And that's why your question is so smart, because if there's an employment agreement that says we will employ our executive director for the full summer festival, or the full period of the summer festival that we run, and that their compensation will be $50,000, and will be increased by 2% every year for 3 years, because we promise we're going to employ them for 3 festivals, then you are going to have troubles unilaterally reducing their compensation. There are ways to do it. But if you've made a promise and you're going to break the promise, you better figure out how to do it without generating liability for breaking the promise. And in a lot of cases, the only way to do it, if it's really an enforceable promise, an enforceable contract, and you're really going to change it and break your promises, you're going to have to negotiate. Does that answer your question?
Wonderful. Thank you, Judy.
What else?
Well, I think the last piece is the idea of some organizations using separation agreements at the conclusion of this. So just any kind of best practices, do you use them as part of your practice? You suggest organizations having this be part of their process at the end of an employment with an employee?
Like so much in this field, it varies with the situation. Paying severance when you terminate an employee and having them sign a separation agreement is critical to protecting the employer in certain situations. And I deal with them all the time. The most important components usually of a separation agreement are the part where the employer gives the departing employee some benefit, usually almost always money. We'll give you some money. We'll give you a couple weeks pay or 6 months pay, or outplacement services, or we'll extend your health insurance. We'll pay your COBRA payments, or something. And then the next part always says that the employee releases all claims that they may have against the employer, because they're getting this payment. They promise that any wrong that the employer might have committed against them, they are releasing any legal claim they might have on the basis of those kind of violations. And then the worker also promises they won't sue, and they promises that they will, again, maintain confidentiality over the IP, blah. In the for-profit world, there are some limited situations where in those agreements, you can also get someone to say they won't compete. I imagine that is unusual in this community, but I can also see situations where you'd want it. That's what a separation agreement usually means, or what it usually is. To me, it feels incongruous to have a conversation about severance and separation agreements in the context of a talk about a company that has run out of money and is closing down or dissolving. It brings up a kind of a basic principle or approach that I haven't really addressed today yet, but is critical to close down any business, especially a not-for-profit, which is taking into account the reality of the situation and the human costs of what you're doing, and the importance of avoiding extreme actions that arise out of anxiety, to try to put in place belts and suspenders and crossing I's and dotting T's to limit some abstract, unlikely legal risk, and putting all your energies in that direction, blind or not blind, actually, I apologize to anybody that I've offended by using the concept of visual impairment in that way. If totally ignoring what's right in front of us, which is we're out of money, and if somebody sues us, like, the legal risk is abstract and not likely to happen, but the bank account says we're out of money, and that is real. All this to say, doesn't make sense to me to worry about giving somebody a big extra cash payout to avoid them suing you, and avoid a damages assessment by a court in 6 months, when you're already going to be bankrupt by then. You're not even going to be in business then. And you're a not-for-profit, you're a public charity, you've got human beings in front of you. Take seriously the human impact you're having on people, and think seriously about whether that money is better spent easing the human existence of the people for whom you're responsible for, and do so in a way that's equitable. Again, if you get too bogged down in separation agreements, you're likely to give extra money to the people in privileged positions. You're likely to give extra money to your executives, to your white collar workers, to your highly trained, highly compensated workers, because you're trying to avoid a legal risk from them that would be a big payout to them. And what you're doing is then you're transferring more of the wealth to the privileged people, likely to be privileged in terms of race, likely to be privileged in terms of gender as well, and in so many other marginalized identities that have put them in the position of privilege. And you're likely then to be preventing the people in the more marginalized identities in terms of race, age, gender, everything else, who are going to walk away, and you won't even think of paying them extra because you can't imagine them signing a severance agreement. Long-winded answer, but that's the balancing that I hope you all take seriously if you do unfortunately have to dissolve your organization.
No, agreed. And I think that's another component where nonprofit finance comes in. If you're doing this intentionally and you're doing it in advance and not in a reactive way, then it allows organizations to take all that into account. So that was totally agree. All right. So as we kind of conclude this kind of portion, I just wanted, and you actually covered this in your previous answer, this question of, since we're doing this kind of planning forward a bit more, what are ways that boards and senior staff can get prepared to have a conversation, either, with their HR lawyer or with their consultant, or even with their their finance consultants. And so you actually answered some of these of getting their documents in order and what you would look to see and read in advance to make sure that they are meeting the obligations that they had already put in place. So I'm not sure if you want to just if there's anything here that you didn't answer in the previous one. You talked about employee manuals, talked about offer letters, contracts with workers, updated vacation salary. So you actually answered pretty much all of this. Any final thoughts, Judy, before we move on to the next component, which is dissolution from an HR perspective?
When you are going through the process that Jim just described of pulling together your offer letters, your documents, what you really are paying people every week, what your payroll looks like, what people's jobs are, this and that. If you don't have offer letters, if you don't keep personnel files nicely, don't get distracted by that failure to meet those obligations. Instead, take stock of however you have communicated your commitments to your workers. If you don't have offer letters, but you generally text people when you make an offer, or you hired somebody 20 years ago and there's a piece of paper on which you jotted down the terms and conditions of their employment, pull that piece of paper out, pull that text out. Don't worry about don't worry about the format of any of these kind of communications. that we're talking about, just focus on what is it that you have communicated in the past to your workers, and how can you responsibly meet the obligations to the best of your ability, and then again change the status of what's going on if you can't meet those obligations.
All right, perfect. Thank you so much. Now, Judy's still going to be here for the other conversations because obviously there is an HR component to the next two pieces that Luke will do, kind of an overview of dissolution, then an overview of kind of bankruptcy. But so we'll still, if you have questions as we go with respect to HR, as Luke goes through this, please put them in the questions as well. And we can always, attempt to answer them as well. So
Yeah.
thank you again, Judy.
And that's a really helpful point that Judy and Jim ended with, is that one of the things that makes such a huge difference for us when either representing clients, when Jim or I represent clients ourselves, or when we try and refer VLA clients to counsel, just having the documentation, even whatever you have available, even if you don't have kind of the immaculate personnel records that are all nicely organized and archived in such a clean way, as long as you have the records together and you're able to fairly quickly get them organized and transmit them to an attorney, it makes such a difference. It makes such a difference for the attorneys helping you and their staff, just kind of helping put together the story based on reconciling what we're hearing from you as we have our conversations with what the documents actually reflect. So yes, I totally agree with Judy's sentiment of don't agonize if you don't have the documents that we ideally would want you to have. What's most important is if you do have records of communications and exacting certain policy or exercising or executing certain policies, as long as you're able to share those with us and help us kind of in that effort, it does make a huge difference. But with that said, we're going to move on to kind of the next two topics, which really are more of a nuts and bolts overview of nonprofit dissolution and bankruptcy. And bankruptcy is a little bit less common in the nonprofit space, but it helps to at least understand the general framework of how these two procedures work, because they really are a procedure. So first question is, what even is dissolution? And dissolution is generally the winding up and closure of a business entity, typically a registered business entity like a corporation, a limited partnership, an LLC, et cetera. But it can also include things like sole proprietorships, general partnerships. The reason that we have these types of, that this conversation is helpful is because with a charitable 501c3 nonprofit, there is a little bit of extra work in order to dissolve. It's not as easy as in the for-profit sector of, pay off any outstanding claims, any outstanding legal obligations, return any capital to our initial investors, be it LLC members, partners, shareholders, et cetera, and then, basically close up shop. Because particularly tax-exempt nonprofits are part of, they're publicly owned organizations in the sense that, they're supported by members of the public who provide charitable donations. You have certain reporting requirements. So those of you who manage and sit on boards or run nonprofit corporations are familiar with, there's many levels of reporting and, information sharing with, various levels of government, the state secretary of the Commonwealth, the state Attorney General's office, and then you're the Internal Revenue Service for your tax exempt purposes. So as with business formation and maintenance, the same goes for dissolution. You're still going to be reporting to these three levels. So it is a little bit of a process. Should we dissolve? Does it make sense for us to do that? It depends on a number of factors. And this is a saying that you're going to hear from attorneys all the time, is it depends. Do you feel that you have fulfilled your mission and there's no more work to be done? I'm sure few of the organizations who are thinking about dissolution think about it for that reason. We always have more work to do. There's always more communities we can serve. There's always more needs for what we're doing. More commonly, have you become unable to support yourself financially? Have you decided to merge as part of the strategy of dealing with financial hardship? Have you decided to work, connect yourself with another affiliate in some way with another organization, be it through a bona fide merger where we both become a new entity, we get absorbed, or a program of ours gets absorbed by another organization, or what have you, or we just closely collaborate and affiliate. Or have you suffered a fundamental departure or breakdown in your leadership? Have all of the board members resigned? There's no more executive leadership. There's no more high level leadership. There's really no one to steer the ship anymore. These are some of the things that might prompt you to think about, is it time to, shut our doors, or is there something else we can do? So the first thing to really understand, and we're going to talk about this at a very high level, we're not going to go super in depth, because honestly, this is dissolution is its own 2.5-hour workshop by itself. But understand that it is a process. Even with the for-profit space, where it's relatively a little bit simpler, it is a process, and you have to understand that there are certain discrete steps to it, and filings and reporting requirements that you have to make sure you're fulfilling in order to actually successfully dissolve your organization and wind up its affairs. And for nonprofits, there's two avenues of dissolution. There is one, and they depend on whether or not the organization actually has assets. And this definition here is actually provided by the Attorney General's office, their public charity division. And it's basically, we consider you to have not had assets if you've never operated or received any funds. Fairly straightforward. You currently have no remaining funds, or you will have no remaining funds or property after you've satisfied all of your outstanding debts, liabilities, claims, etc., including your costs associated with actually closing down. One thing that I want to touch on briefly is you can't necessarily spend down your assets in order to make yourself a no asset organization, unless, of course, the way you're spending it, or the kind of grant making you're doing, is consistent with your charitable purpose, which is identified in your articles of organization, your initial application, your form 1023 with the Internal Revenue Service for your application for tax exemption. So one kind of easy, somewhat intuitive strategy people might think of is, oh, I'll just spend down my assets. We'll buy this or give away this. If it's not consistent with your charitable purpose and not directly part of your charitable purpose, then that is not going to fly. And all of this is going to be evaluated by the Attorney General's office, whose job it is and whose jurisdiction it is to review the affairs of charitable organizations in Massachusetts. So if there's anyone who's going to have an issue with it, it's going to be them, and they're going to be the ones who are ultimately blessing the closure of your business. But this is where the paths branch. Do you have assets or do you not have assets? And there are advantages and disadvantages to both. Typically, if you have no assets, it's a little bit easier. If you have assets, the challenge is that it requires the consent and the blessing of the Supreme Judicial Court of Massachusetts, which is our state Supreme Court. And this process is really filing a complaint. It is a formal legal action before the High Court of the state of Massachusetts. Alternatively, if you have a no asset organization, you currently have no cash, you don't have, you've been able to distribute consistent with your mission, any personal property the company has, then you can do what's called an administrative dissolution, which really just means you're getting the green light from the Attorney General's office. You do not need Supreme Court consent in order to do it. So this, we go through a petition. It's submitted to the Attorney General's office. It can be done pro se without counsel, but as with anything, any legal process, we strongly recommend that you do at least consult with an attorney about this process, understand what the steps are, get some guidance, get someone to kind of hold the business's hand through this process, because it does make a difference. And it also, just a nonprofit or corporate attorney who's familiar with this, they can anticipate the types of questions and the types of concerns that, a reviewing body, be it the court or the Attorney General's office, will have about this process. So they're just trained, they've been through this, and they understand. So that really is the value of working with an attorney on this type of process and understanding it. Even though, again, the no asset dissolution is a little bit more straightforward. So we're going to start with no asset because it's a little bit easier. Basically, this is kind of your checklist for what you need to include and what you need to be thinking about. One, make sure you're actually registered in the state. Make sure that you have you've been filing your annual reports with the Secretary of Commonwealth to ensure that the business has, continued going. You, as a public charity in Massachusetts, you have an obligation to file an information return with both the IRS and the Attorney General's office. Here in Massachusetts, it's your Form PC. Have you submitted all of your annual filings, your Form PCs, for the last 4 years? And then importantly, it does fall upon your board. And this is something that you will see in your corporate bylaws, most likely, is the process for how we're going to dissolve ourselves. And as part of being a tax-exempt 501c3, you have stated somewhere in your organizing documents what is going to happen when your corporation, if it dissolves. And you state basically that all of the assets of our organization are going to go to another mission-aligned, charitable, tax-exempt nonprofit. But ultimately, you will find in your corporate bylaws a provision relating to what is the process for dissolution? How many votes do we need? What constitutes a quorum? Do we need a quorum, or do we need a majority of all directors in office? That is going to be set by your internal policies. You need an officer's certificate actually affirming that the board has taken action on the dissolution. And then you will complete what's called a dissolution package that's submitted to the Attorney General's office with a variety of filings, including the petition, any remaining filings, any statements regarding the financial status of the organization, et cetera. And then the Attorney General will review, and best case scenario, they will send a final notice of dissolution, which indicates that the nonprofit has been dissolved. And after that point, you have to notify any other state and federal authorities that the organization has been dissolved. Again, the Commonwealth, or the Secretary of the Commonwealth, the Internal Revenue Service, you do have to report to the IRS that your tax-exempt organization has now ceased to exist. So this is a general overview of the process. Again, just to help you understand kind of the framework, the steps that are involved, and also understand that this process does take effort. And if there is, another way for you to continue to sustain yourself, and fortunately, again, with the PPP and the various relief efforts, I think we've avoided kind of getting to this point so far, but just understand that you do have to do work. It's not as simple as just shutting the lights off and no one going back and, no longer having board meetings. You still do have to take affirmative steps to dissolve a business. So on the other hand, when you have an organization with assets, it's a little bit more complicated, particularly in part because, well, now where do the assets go? And this gets to that point that I mentioned that is in your organizing documents required for your tax-exempt status. You have to identify a receiving entity that's going to receive the leftover assets. And they have to either be mission-aligned, have a similar mission to your organization, or they have to agree only to use your assets for purposes that are in alignment with your organization's stated mission. So that is part of the challenge, and the Attorney General's office is going to take that very seriously, and they're also going to take geographic proximity very seriously. If you operate a symphony and you have certain personal property, then upon the dissolution, maybe you've identified another symphony in Chicago, but the Attorney General's office will say, well, why haven't you picked one here in Massachusetts? Why haven't you picked one that's local? We want to we have paid members of the public, many of us probably from Massachusetts, we have supported this organization, so that money belongs to us and it should come back to us in some way by supporting another organization, another charitable mission located here. So there's those two priorities is, who, in terms of, is your mission aligned with what we've been doing? And then where are you, do you kind of represent the constituency that has supported you, the public that has supported you? And then the second step is similar, parallels for a no asset dissolution. Again, verify that the corporation is registered with the state. Make sure you've submitted any remaining annual filings, your Form PCs. Adopt the board resolution. The officers has to certify that that resolution has been taken and submit the dissolution package. Now, the added step is that you also have to file a complaint in the Supreme Judicial Court of Massachusetts. Again, that complaint for dissolution. And that's fairly, the complaint itself is fairly straightforward, but you do have to make sure that that information is accurate and correct, and you may have to make sure that you're timely completing those. And then basically after the Attorney General's office has had the opportunity to review it and return it to you, then it will go to the High Court of Massachusetts, and they'll review the pleadings, make sure that everything is in order, and if it looks appropriate to them and you've identified a good receiving organization that it's fitting, and all of your affairs seem satisfactorily wound up, then they will authorize the transfer of the assets through what's called an interlocutory order, basically kind of an intermediate order during the pendency of a lawsuit. So then after that, it's follow the instructions. The court will issue an order, the interlocutory order, do what they say, transfer the assets as you planned for and as the court has ordered. And then you'll have to submit a packet confirming that this has all taken place to the Attorney General's office. So after this process, it'll go back to the Attorney General. They will either assent, if everything goes well and is still satisfactory, they'll consent, send it back to you for filing, and then it will go back to the SJC again, and they'll review the entire thing, docket it, and then issue a final judgment indicating that the corporation is finally dissolved. So it's a bit of a process. It's kind of bouncing back and forth between you, the Attorney General's office, and the Supreme Judicial Court. Basically, come up with your plan, submit that to the Supreme Judicial Court. This is what we intend to do. This is who we've identified. This is, where we're at. We're in compliance with all of our state, federal, and local obligations. Will you give this your blessing? Yes, tentatively. Go. We're happy with who you've identified. Go distribute the assets. Confirm that you've done so with the Attorney General's office, have them sign off, come back to us, and then we will formally dissolve it and the corporation will cease to exist. So that's the general overview of it. It is between organizations, the process can vary because everyone has different obligations, depending on your organization. To the points that Jim and Judy discussed earlier, you might have different staff obligations, you might have different employee sizes. You might have other outstanding contracts and other obligations. So where you are at and the size of your organization, the budget, et cetera, these steps will expand and contract depending on what your organization is doing, what your kind of footprint is in terms of your obligations. So again, hopefully this is kind of the pitch for why it's important to work with, insurance professionals, attorneys, et cetera, for, understanding this process. So just some general points on this process. Oh yeah, go for it, Jim.
Oh no, I was just opening it for questions. So yeah, go ahead.
Oh sure. Yeah, and if anyone has any questions, feel free to interrupt. I don't see any. So generally, Attorney General's office, they're busy. They have a million different departments. They're doing a million things, even within the charitable organization department. Probably send you to voicemail immediately. Make sure, just best practice when you're going through this process and thinking about it and generally corresponding with the Attorney General's office, have your questions, have your thoughts, have the issues that you need to address with them ready when they contact you. Be prepared is the short version. Again, I already spoke about this at the beginning when we were talking about asset versus no asset dissolution, but with respect to spending down assets, just because, again, if you want to spend down assets, make sure that the way you're doing it, if you are doing it, is consistent with your charitable purpose, your charitable mission. You can't kind of just go rogue and spend money for the sake of making the dissolution process easier and avoiding getting the consent of the Supreme Court of the state of Massachusetts. You really do have to make sure that you are doing it properly, consistent with the mission that you've articulated in your organizing documents. Again, oh, yeah, go for it, Jim.
No, I just want to jump in really quick on this because this is something I've seen over the years, is this balancing act where you are, because we've gotten this call, hundreds of times, where an organization has just decided, okay, it's time. And we just think it's going to be a quick process. And I think if anything, by hearing Luke's presentation, you appreciate the fact that this isn't an overnight process, and it does take time, and even oftentimes takes resources if you're not unable to get kind of a pro bono attorney to do it. So, even just keeping enough assets in order to do this well and appreciating the fact that it does take time, it's also a board management issue. You have to have enough board members to stay on during this process, even if sometimes your programming has been reduced down, or maybe in a sense, people start to leave the ship when you're no longer kind of fully operating, or maybe your executive director has left and that's prompting this, for whatever, including financial issues. So this is a really, and again, I keep saying back to the nonprofit finance, planning, but this isn't a quick fix. It does take resources. It takes time. It takes leadership, even to close.
Yeah.
And that's where this can be challenging, because you might not have any of those resources in order to do this and do this well. So that is a tricky part about this.
Yeah.
And I'll add one other piece, which is a little bit of a connection to our next conversation, which is mergers, absorptions, which is sometimes this is a harder process. And when compared to an absorption or a merger in the nonprofit space is 100 times easier. So it's only one piece of paper for two nonprofits to merge, and you can see the difference, what it takes to actually close down a nonprofit, even if it has very limited resources. Although there are other issues related to mergers and acquisitions and those things, which we'll get to later, mostly around the fear of liability. But I just wanted to tease that out based on just our experience with taking these calls a little bit. Anyway, that's
And you have to see that you can kind of see in this process with business for nonprofit formation and nonprofit closure, there's kind of this inertia to it. There's kind of this resistance that it is a slow, deliberate, challenging process, because, on the beginning, when you're forming, the Attorney General and the Internal Revenue Service want to ensure that you are using the public's money for a charitable purpose, and you're using it properly, and you're using it in a way that's consistent with, what we as individual donors have signed on to. Similarly, when you're closing down a nonprofit, we want to make it a slow and deliberate process to make sure that, those funds are still going to what we, again, as members of the public, have signed on to and we've agreed to in virtue of donating to your cause. So part of it is this kind of we want to make this a slow, deliberate process, because we want to make sure that businesses who say they're going to be operating for charitable purposes truly are doing it. And we want to make sure that they actually take this seriously. So we're imposing a number of requirements on them. But we appreciate that it's, when you're in dire financial straits, it's hard, or just personnel, dire personnel straits, that it is hard to stick with these processes. And that's why we're raising this as part of an overall conversation on exit strategies and ways that you can transform your business or restructure it in such a way to continue surviving, even if we've gone through a different type of legal structure or legal relationship.
And also just from a time management perspective, Luke, so we have about, looks like about 20 minutes, okay? And so if this is where it'd be, if you're here, and I know it's harder for folks who are going to listen to this after, but if there are any questions and, any questions now for, Judy or myself around this conversation, let's take those now. Otherwise, we can go into a very brief kind of overview around bankruptcy language, I would argue, for the most part, and come back with questions. Michael, how does that sound?
That sounds great. Can I add just a resource here that I think some folks might enjoy? So when the Mass Cultural Council was faced with a lot of conversations from organizations considering should they close, should they safe harbor. We actually put a 3-part series out called How to Safe Harbor. One of those areas is what we call soft landings. We use a little lighter language maybe than what the legal side
Yeah,
is.
great
And
language.
so I'm gonna, in the chat, I'm gonna put a resource for everyone here today. This was the 3rd edition of our blog that we put out, and it was all about how to manage in an age of crisis. And one of the tools that we created from that is another one here I'm putting in there is a thought tree. And we developed this with the Nonprofit Finance Fund to kind of look at the questions posed to you and say, what direction should we go? Should we tough it out, or should we investigate this? And one of the questions, and so I'll just put that there. One of the questions that we start with this in this tree is, does your organization have enough cash or access to cash to manage to the point of reopening? If the answer was no to that, we went to the next bucket that was, is it possible to access cash from outside sources? I would say before the PPP and the stimulus, a lot of people said no to that, but that, as we talked about before, came a little bit more with some of the rescue plans. If that answer ended up being no, or wasn't enough to carry operations to the point of initial re-engagement, you really had to say, do we have strong community support and donor support for the work? So really tapping into some of the social capital and the financial capital that exists a part of that. And if you didn't have community support for your work, or donor support for the work, then we started to think about what does a soft landing look like? How much money does that cost? That was a major thing that we were talking about. It's not free to do all the things that you just mentioned, Luke.
Yeah.
There's a considerable amount of runway that happens. Some collecting organizations may need 3 years or more to do this timeline because of the collections they have, because of the endowments that might be there, and to go through this with also an additional public campaign of communication very early in this process is something that may take a long time. And so just to know that doing this is not free and it's not very fast. So one of those things is getting out in front of it as much as you can with a thought tree there, if that's helpful for anyone, to think about what are the questions that you might want to ask of your constituent, your board, your leadership, your staff, in order to direct us down a certain path.
Yeah, and your funders and your supporters, definitely.
So if that's helpful, we put that out there as a resource.
Yeah, that's a great resource.
Judy, I think you had a note that you'd like to mention.
Would. For those of you who have mergers or absorptions in your list of possibilities, I just want you to be aware that there's one more law that could easily get triggered relating to your workers, and that is the Massachusetts WARN Act. The WARN Act creates obligations for employers if they're going to terminate or move the work location of their workers on any large scale. It's one more legal protection for the workers who are always at a power disadvantage in the employment relationship. And so if you're thinking of a merger or absorption that would result in the jobs in your organization moving to a different location, just check out the WARN Act or ask your lawyer or ask people about the WARN Act, because if 12 positions or more move location, you're going to have to give certain types of notices under the WARN Act. That law also creates significant obligations to give notice if you are closing down a plant, including a not-for-profit that has 50 or more workers. I didn't mention that because I was under the impression more of you would be working for smaller organizations, but also be aware, if you're larger, if you have 50 workers and your next step involves terminating 50 workers, you will also have to comply with the WARN Act.
Thank you, Judy.
Awesome.
And my intrepid colleague, Sarah, has already placed a link in the chat to support your statement, Judy. So thank you for doing that. We do have, let's see, a question came in. Is it possible to merge a nonprofit with a for-profit?
That one's going to be, that's a good question. Oftentimes for-profits do sometimes have subsidiaries that are nonprofits. You see that in corporations that have foundations. Technically that foundation is a 501c3, although sometimes people don't think of foundations as 501c3s, there actually are. So again, it's a public asset. And that wouldn't necessarily be a merger, as it would be have to be approved by the secretary, approved by the attorney general's office. You see that sometimes in hospitals, and even if you just go to the globe and look in kind of nonprofit hospitals being merging with a for-profit hospital, it has happened in the past. But again, it's going to be a higher sense of scrutiny. So I think it's a good question, and it's going to be more fact dependent. And we can definitely take that, if that's a question of a group trying to do that, please contact the VLA and we can get some more resources for you on that. And then also it's a great question for the other workshop we're going to do. So in general, no, that's going to be pretty hard, but there are potentially ways to do it with approval.
Yeah. It all boils down to this interest by the IRS of nonprofit charitable corporations, 501c3s. They don't exist for the public or the private benefit of any named person, whereas, for-profits do. You have your named shareholders, you have your named members. So when those are inconsistent or coming into conflict, then yeah, it's going to be a harder sell. So with this last few minutes, I'm going to do a really, really rapid fire kind of, to Jim's point, introduction to really the vocabulary around bankruptcy. There are a half a dozen varieties of bankruptcy. I'm sure the most common you've probably heard of are Chapter 7, which is liquidation, meaning we are placing the business assets in control of an independent third party, and impartial third party, and they will distribute all of those assets to the creditors. And then Chapter 11, which is restructuring, meaning we are going to continue our business as an ongoing concern, meaning we're still conducting our business, but we're going to do it kind of with supervision, either from a trustee, or we're going to have heightened obligations on ourselves to conduct ourselves consistent with a reorganization plan that has been approved by both the creditors and the bankruptcy court. So basically, in short, what is bankruptcy? It's a proceeding that basically allows for individuals and organizations to find ways to relieve themselves in a manner from certain types of debt. It is federal law. It's handled by your United States courts, not state courts. And really, it either eliminates your debt, or you create a repayment plan, or you create a reorganization plan for how you're going to continue conducting yourself. Like I said, there are about half a dozen varieties of bankruptcy. Again, the most common ones are Chapter 7 and Chapter 11 are the ones that we hear of most frequently, liquidation or reorganization. But there's also, Chapter 13, another more common one, mostly for individuals and sole proprietorships, not relevant so much to this audience. But to come up with a repayment plan for your creditors. So not necessarily going out of business, but we still have to fulfill our obligations to our creditors. It hasn't completely eliminated those obligations, but now we've come up with a plan for it to be more reasonable and doable within the resources that we have. So I'm not going to go through all of this, but there are a number of educational initiatives that are, I believe, mandatory for you to engage in a bankruptcy process. Certain counseling programs, basically to make sure that you understand the process and that you understand that there are legal consequences and financial consequences on this, and that you do have a plan for how you're going to resolve and how you're going to kind of avoid these problems in the future. And for some of these, you do actually need to have proven that you've completed these courses in order to get even a bankruptcy court to be willing to hear your claim. So we're not going to go into the details of all this. Again, it's assessing your financial situation. I believe this is more for individuals. But we're going to talk a little bit about, introduction to liquidation. We're mostly going to talk today about Chapter 7, Chapter 11. Basically, it's as it sounds. It is a process that allows the owners of the business, the managers of the business, to liquidate the assets of the business in order to satisfy their outstanding debts. So part of it is the business ceases to operate, and we've had a court order, we've had a process where we decide the priority of how the claims are going to be paid, how the debts are going to be resolved to our creditors. And as we've said with, mergers and acquisitions, dissolution, all of this stuff, all of this is extremely fact specific. All of these processes what actually happens in the court and what the priorities are going to be. It is extremely fact specific depending on your financial situation and what your outstanding obligations are. But generally, we are going to take an account of all of your outstanding debts, your assets, and we're going to do our best to make sure that those assets go to those creditors in some type of rational order. Individuals and businesses can both liquidate. For individuals, it kind of gives you a fresh start. For businesses, it does give you, a somewhat relief and from the business debts. And for businesses in particular, establish separate entities. There is the separation between the business's debts and, if you're in the for-profit sector, the owners. So in that regard, there isn't personal obligation. There isn't personal liability for the owners of the organization unless you're a sole proprietor. You are the business. A little bit wonkier for partnerships, just because again, there is that kind of less of a separation between the constituent owners of the business and the business itself in a partnership. But this is generally, it is available to both individuals and businesses. There are some fees associated with it, a little less onerous on the individual and liquidation side than, as we'll see, with the restructuring side. This is just kind of a brief chart showing all of the various filings and kind of the visual representation of the process and what needs to be submitted into the court in order to file for Chapter 7 liquidation. So generally after filing, a trustee will be appointed. Any collection actions, any outstanding efforts by your creditors to retrieve those debts, to satisfy those debts, are going to be halted. The bankruptcy court is going to put all of these creditors on notice that there is a bankruptcy matter pending. The debtors do have to meet with all of the creditors. The debtor must turn over their property, their assets, to the bankruptcy trustee, the impartial third party who is going to basically manage the bankruptcy, the distribution of assets. And then the trustee is going to, again, distribute all of those assets consistent with, whatever orders the court has provided, which are usually going to be governed by, federal bankruptcy law. And there is a priority in terms of, what are the types of debts that you have to satisfy. There are certain priority debts, which are usually court fees, legal fees, administrative fees, things like that. Secured debts, which are, debts, obligations that have been secured by some type of property interest. Think of, collateralized debt, things like that. We've given something in exchange that basically, if I default on my obligation, the lender will own that piece of property that I've given to them as collateral. Those are kind of second in the pecking order. And then, if there's anything left over, then there are unsecured debts, which, don't have any type of property attached to them. And those are, oftentimes those creditors are kind of out of luck because there might not be any assets left over to go to them. So ideally the end of the, with a liquidation is going to be the discharge, meaning I have no more liability. I have my, my claims have been satisfied, and my debtor can't collect against us anymore. And this is something I mentioned earlier, kind of with the distinction between personal liabilities and financial liabilities. So bankruptcy isn't going to erase your personal obligations, your personal liabilities. So, any what we call tort claims, personal injuries, things like that, fraud, any other types of like legal claims and lawsuits. This really just does deal with your financial obligations, your financial claims. So advantages. It is transparent, to somewhat satisfaction of all parties involved. You have a neutral third party, you have an independent third party who's making these decisions and overseeing the process. And it does eliminate your debt, but it does also leave you with no assets and often, result in the closure of the business afterwards. So, cost benefit analysis. But again, this is one potential avenue. And then reorganization is the alternate one. And with businesses, we hear of this all the time. You know, when you hear the news, pick your headline of this, major retailer has gone, filed for bankruptcy, but they're still operating. This is usually what's going to happen. I'm sorry, that's still another typo. So this should say Chapter 11, not Chapter 13. Chapter 11 does allow the business to restructure, reorganize, but it's under the supervision of a trustee. So we still have that bankruptcy trustee. We still have that neutral third party who is participating and overseeing the process. But now, instead of coming up with a plan for just satisfying the debts, now we have to come up with a plan for how are we going to continue to operate ourselves? How are we going to continue to operate as an ongoing concern to the satisfaction of our creditors and the court? We've gotten ourselves into default, so now we have to prove ourselves. So that's generally what that looks like. And really the key difference here in the procedure is we're coming up with a plan that has to be agreed to by a number of parties. So instead of coming up with like a liquidation plan, now we have to come up with how are we going to satisfy our debts? How are we going to continue to operate? How are we going to handle, how are we going to manage our company's assets? How are we going to avoid causing further or falling into further defaults in the future? You submit that to the bankruptcy court. The bankruptcy court poses it to some of the creditors, particularly ones who will be most harmed by the bankruptcy, to the restructuring to they vote on it and then goes back to the court for their final approval. And if all goes well, then it will be it'll be certified and the debts will be discharged. But now you have to basically follow your plan, and you will be subject to the agreement. So I'm going to stop here. This again, kind of like dissolution, is its own separate 2.5-hour conversation. So I'm going to leave it for if anyone else has questions, and I will put kind of our instructions for how to apply for legal assistance through our office.
That's great. That's great, Luke. I mean, it is a process and it is complicated and it's loaded with its own lingo. So it is good to kind of introduce it. But like you said, if people are thinking about this and planning, especially using other resources, it definitely requires a separate, application, or through board members or through your other resources to really do this well. So, Judy, any final thoughts kind of from an HR perspective related to kind of bankruptcy from your perspective?
Nope. Thank you. Good luck to everybody. And feel free to reach out to me if you have questions. I'm happy to answer isolated questions. I have a website, Policheck HR Law, and you can contact me through that. Good luck to all.
Thank you, Judy. Thanks for all your help.
Thank you so much, Judy.
I appreciate it. Michael, back to you to kind of close us out. Is there any outstanding questions that we haven't answered? Is there any kind of closing thoughts based on Mass Cultural Council's perspective as we?
No, I'd say, well, first of all, thank you to the three of you for providing this valuable resource, and we'll have this recording and available. I find it as a promising piece that we got a lot of requests for this last year and less for now. So I feel like folks have found some resources. The stimulus is working to a bit. The increased funding and our organizations have done a tremendous job fundraising like crazy. And so, but it's helpful to know what that path looks like. So as you're looking at what strategies, depending on what kind of crisis we're looking in the future, just to know a little bit of the nuts and bolts of what's ahead of you. Before we close out, because we're almost right at time, Luke and Jim, do you want to just give us two cents about your upcoming webinar on the merger topic? What will include?
Yeah. I mean, again, I agree with you. We thought we were going to get a lot more requests at this point, but I think it's a testament to the people's work and their pivoting and finding new ways to engage audiences and fundraise. So it really is truly a testament to everyone's work, that this isn't yet a crisis, and we're glad about that. This is not the work we enjoy doing, for sure. On the mergers piece and acquisitions and absorption, same idea. It really just meant to be a continuation of the conversation. So definitely let us know in advance if there are particular questions, but this will be an extension of that. And obviously that's a different type of change, but it has similar planning, and has similar thinking, and it has similar approach, and in many ways has similar complement to the other workshops as well. So.
Great, thank you. And thank you everyone for coming today. We'll just wrap out right now. The contact information for the Arts and Business Council is right there. Thank you to Judy, Jim, Luke, and Sarah for providing all the resources. Sarah put the link for the merger and absorptions down in the chat if you want to go ahead and register for that. With that in mind, thank you so much and have a great rest of the afternoon. We really appreciate it.
Bye, everybody.
Thanks, Michael.
Bye.
Thank you.